Article 165, Source. Canon 2492. Source of fact is the primary person, place, thing from which a fact has come or is acquired. Canon 2493. When the source of a claimed fact is obtained through documentation, it may be classed as a source. Text and such information must be referred by citation. Canon 2494. There are three forms of source text being primary, secondary, and tertiary. I. A primary source text is first-hand written evidence and testimony made at the time of the events, by an actor or witness to such events and whereby the provenance of such evidence is verifiable. And 2. A secondary source text is written accounts of history based upon primary source texts or a claimed reprint or approximate reproduction of an alleged primary source text in which no primary source text exists. And 3. A tertiary source text is any compilation of secondary sources and excerpts from primary source texts. Canon 2495. A source text cannot be considered to be a primary source text if the text is a claimed reprint or approximate reproduction, or the text is derived from an extract of a secondary source text to imply the existence of a primary source but the original is missing. Canon 2496. A source text cannot be considered to be a secondary source text if the text is a claimed reprint or approximate reproduction, or the text is derived from an extract of a tertiary source text to imply the existence of a secondary source but the original is missing. Canon 2497. A claimed fact derived from a valid primary source text shall always have higher standing than a claimed fact derived from a secondary source text. Similarly, a claimed fact derived from a valid secondary source text shall always have higher standing than a claimed fact derived from a tertiary source text. Canon 2498. As the Roman cult, also known as the Vatican, also falsely known as the Holy See, did in part admit in its actions in Ecclesiae Christi July 28, 1591 to the deliberate creation of false and fraudulent source texts, including the destruction of countless true original source texts and the absurdity that such false and fraudulent documents are legally permitted to be argued as true and correct. All source texts originating from the Roman cult, including all historic legal texts used by the cult to claim their authority and position, are hereby null and void from the beginning when they were first issued. Canon 2499. No source text deemed a fraud in part or whole, in accordance with these canons, may be used as a valid source text in law. Article 166, Reference. Canon 2500. A reference is an abbreviated identification of another document source within a body of text, including a complete and formal identification at the end of the text. A valid reference is known as a citation. Canon 2501. A valid citation is any reference that conforms in form to the requirements prescribed by these canons in accordance with Pactum de Singularis Caelum. Canon 2502. A reference is not a valid citation but an inferior reference, having no validity if it does not conform to the requirements prescribed by these canons. Canon 2503. There is no higher form of authority of valid citation than these canons. When anyone references, writes or speaks of citation, valid citation, or highest authority citation, it shall mean these canons and no other. Canon 2504. Excluding the sacred covenants, charters, scripture, codes and canons of Okadiah and one heaven, no text of historic significance, or of more than 20 words that represents an exact likeness of an earlier source may be included within a more recent text without valid citation. Failure to provide valid citation is an offense known as plagiarism. Canon 2505. All valid citations comprise 3 3 elements, and inserted abbreviated reference within the body of some text known as a CITO, a more formal and complete reference at the end of a page, chapter or division of the document known as a prefero, and a comprehensive summary of all sources as an appendix to the document known as a summarum. Canon 2506. When considering the three elements of any valid citation, an author may choose one of two valid systems of citation to use throughout their work: notational citation and parenthetical citation. Only one system may be used throughout a whole document. Canon 2507. Notational citation is a system of valid citation whereby the use of CITO within the body of text is as superscript sequential numbers, corresponding to a correspondingly numbered prefero at the bottom of each page or at the end of the chapter or division, and then the summarum at the end of the document. Canon 2508. Parenthetical citation is a system of valid citation whereby the use of CITO within the body of text is through short abbreviated text within correct brackets or parenthesis, corresponding to alphabetically or time-arranged prefero at the end of the chapter or division, and then the summarum at the end of the document. Canon 2509. When using parenthetical citation, all references to inferior Roman law, Sharia law, or Talmudic law sources must be in square brackets denoting their inferior status, with any other source permitted to use rounded brackets. Canon 2510. When referencing a valid canon of these canons as a CITO, the word canon followed by the appropriate number is sufficient, or the abbreviation can and then number is appropriate. Canon 2511. Any document that uses the word canon or abbreviation can to specifically denote some false an inferior canon as a CITO and does not isolate such a reference in square brackets is itself automatically null and void from the beginning. Article 167, Verification. Canon 2512. Verification is the substantiation or proof of an assumption such that the assumption may be regarded as true and therefore fact. Canon 2513. A fact may be regarded as verified when the substance of it has been compared to these canons and found to be in accordance. Canon 2514. Where any entity, organization, association, aggregate, body politic, person or thing is proven to be habitual historic purveyors of forgeries, frauds, and misinformation, nothing stated, presented as proof by them or their agents may be taken as verification of fact or truth. 5.3 Evidence. Article 168, Evidence. Canon 2515. Evidence is any manifest valid form to a minimum standard of proof that can be produced during any formal argument which is deemed relevant and may support or refute a fact that has been stated as part of the proceedings. Canon 2516. The valid form of evidence is evidence which conforms in its appearance, source, handling and presentation to the rules of admissibility and is in accordance with these canons. Canon 2517. Standard of proof of evidence is the level of validity and claim associated with evidence that supports and satisfies any associated burden of proof in bringing forth an argument. There are three forms of standard of proof associated with evidence. I. Evidence beyond a reasonable doubt is the highest standard of proof through evidence when the evidence presented leaves no reasonable doubt in the mind of a reasonable person that the facts supported must be true, and 2. Clear and convincing evidence is the second highest standard of proof through evidence when the evidence presented leaves little or no reasonable doubt in the mind of a reasonable person that the facts at issue are supported and are in all probability true, and 3. Excessive and reasonable weight, preponderance, of evidence is the minimum standard of proof through evidence when the evidence presented leaves little or no reasonable doubt in the mind of a reasonable person that the facts presented by one party are more convincing than the material presented by the other party and are in all probability true. Canon 2518. Relevant evidence means evidence admissible by law having any tendency to make the existence of any fact that is of consequence to formal argument more probable or less probable than it would be without the evidence. Canon 2519. In all criminal matters, the standard of proof through evidence must always be beyond reasonable doubt. However, in matters of civil law, the standard of proof may be distinguished between the superior standard of clear and convincing evidence versus the lesser standard of excessive and reasonable weight, preponderance, of evidence. Canon 2520. Only three valid classes of evidence exist: physical, testimonial and inferential. I. Physical evidence is any physical object which may be considered relevant to an argument in that it provides physical support or rebuttal to a statement of fact, and 2. Testimonial evidence is any sworn testimony by a witness having been given either in an open court, video recording, or written statement, and 3. Inferential, or circumstantial, evidence is any combination of admissible physical and or testimonial evidence which when taken as a whole through the use of logic, reason, and inference, implies the existence of further evidence which is unable to be physically submitted at the time of proceedings. Article 169, Physical. Canon 2521. Physical evidence, also defined as real evidence, is any form or parts of a physical object intended to support or rebut a fact associated with an argument. Canon 2522. There are six broad categories of physical evidence, being object, material, chemical, biological, documentary and digital. Namely, I. Object is complete or self-contained objects, whether instruments, firearm, powered, non-powered, clothes, etc., and 2. Material is parts of any material such as fiber, metal, stone, etc., and 3. Chemical is part of any chemical reaction, residue, gunpowder, fingerprint reaction, etc., and 4. Biological is any biological culture, sample, body part, or whole, and v. Documentary is any printed documents, and 6. Digital is any digital files, audio, video, transactions, recordings. Canon 2523. The validity and therefore admissibility of physical evidence relevant to an argument is dependent upon three major qualities, being provenance, method of collection, and integrity, namely, I. Provenance signifying the ownership history of the object and its chain of custody, and 2. Method of collection signifying how the object/evidence came into possession of the party now seeking its inclusion as evidence in the argument, and 3. Integrity of the object/evidence excluding any possibility of alteration, tampering once collected, contamination, or the exclusion of significant degradation beyond recognition since it was collected and registered. Canon 2524. The provenance of evidence signifying the ownership history of the object and its chain of custody is an important quality affecting the validity and therefore admissibility of physical evidence. As a result, there are several essential criteria that must be met in order for physical evidence to be accepted and admitted as valid evidence, namely, I. That the evidence has not been fraudulently manufactured, positioned, manipulated, or altered in any way, and 2. That the evidence has not been obtained through fraudulent means. Canon 2525. The method of collection is an essential quality affecting the validity and therefore admissibility of physical evidence. As a result, there are several essential criteria that must be met in order for physical evidence to be accepted and admitted as valid evidence, namely, I. That the date of obtaining and recording the evidence, or the act/event in question does not exceed the statutory limit of charges and/or suits been brought for such a civil or criminal offense, and 2. That the collection and/or submission of evidence has been properly recorded in a record of evidence and witnessed by a clerk of a court independently of formal investigators, and 3. That the evidence has been collected using proper forensic methods and has been properly sealed and stored securely. Canon 2526. The integrity of the object/evidence is the third essential quality affecting the validity and therefore admissibility of physical evidence. As a result, there are several essential criteria concerning integrity of the storage and protection of evidence, namely, I. That all reasonable efforts have been made to ensure the evidence has not been accessed or handled other than through the formal proceedings to which it relates, and 2. That its authenticity may be examined by a formal expert called by either the prosecutor or defense of a formal proceedings, and 3. That it may be represented to formal proceedings on request, and 4. The forensic procedures by which evidence is collected must be able to prove that in its obtaining and in its processing it has not been contaminated by external sources that may potentially account for its existence, and v. All evidence obtained forensically must be recorded properly and able to be subject to scientific/expert testimony and cross-examination. Canon 2527. Where the accused in a suit has an active criminal record, physical evidence from previous criminal convictions, including the details and circumstances of the previous convictions, are automatically admissible. Canon 2528. Where the same two parties have previously been engaged in a civil suit, trial or hearing, the physical evidence from the previous dispute is automatically admissible. Article 170, Testimonial. Canon 2529. Testimonial evidence is a form of evidence obtained from a witness who makes a solemn statement or declaration of fact under oath or affirmation. Canon 2530. The validity and therefore admissibility of testimonial evidence relevant to an argument is dependent upon four major qualities being competency, integrity, authenticity, objectivity, namely, I. Competency is that the witness is capable of comprehending questions and capable of answering truthfully without influence, and 2. Integrity is the context that the witness has not been offered any financial benefit or that reward has been offered to a witness for their testimony, nor has the witness been threatened or coerced. And 3. Authenticity is that the words of the witness are their own and that they have not been coached in any way by any third party on what to say or not to say, and 4. Objectivity that the answers are first-hand knowledge of fact and not hearsay. Canon 2531. Unless a witness is testifying as an expert witness, testimony in the form of opinions or inferences is generally limited to those opinions or inferences that are rationally based on the perceptions of the witness and are helpful to a clear understanding of the witness testimony. Canon 2532. No testimonial evidence may be taken in court by a court official unless they themselves have agreed and declared themselves to be operating under oath. Article 171, Inferential. Canon 2533. Inferential, or circumstantial, evidence is any evidence inferred through the application of the tools of logic and reason based on prevailing physical and/or testimonial evidence. Canon 2534. The validity and therefore admissibility of inferential evidence relevant to an argument is dependent upon four major qualities being induction, reduction, deduction, conclusion, namely, I. Induction is the derivation of general principles from specific instances of at least three forms of physical evidence and/or testimonial evidence, and 2. reduction is the logical elimination of possible alternatives to the conclusion derived from induction to validate the inductive conclusion is sound, and 3. Deduction is the testing of both induction and reduction conclusions by the determination of a conclusion from existing known truths, and 4. Conclusion is a summary of all three methods of induction, reduction, and deduction to validate the consistency of any postulation. Canon 2535. Unlike physical evidence and testimonial evidence, the existence of inferential evidence is mandatory in any legal argument, as the application of inference in accordance with these canons ensures the integrity and correct interpretation of the other forms of evidence. Canon 2536. The absence of any valid inferential evidence negates the validity of all other claimed evidence. Article 172, Disclosure. Canon 2537. Disclosure of evidence is the acknowledgement, notification, presentment of physical evidence in the due process of any argument or dispute. Canon 2538. Prior to the commencement of any formal proceedings, all parties are required to fully disclose all physical evidence they plan to present in a formal index of citation properly and uniquely numbered, so that the court and any opposing parties may refer to it by number or by subject name. Canon 2539. Prior to the commencement of any formal proceedings, either party may lodge an application for discovery of evidence in which specific requests for documents reputedly in the possession of another party material to the proceedings is believed to possess or control. The party receiving such a request is then obliged to respond within a reasonable time to the request or give good cause as to why such documents cannot be produced or specific requests are unreasonable or mistaken. Canon 2540. Prior to the commencement of any formal proceedings, either party may lodge an application for interrogatory evidence in which specific requests to answer certain questions are put to the other party material to the proceedings. However, no question may be put that directly accuses the other party of an offense. The party receiving such a request is then obliged to respond within a reasonable time to the request or give good cause as to why such questions cannot be answered. By default, unanswered questions of a valid application for interrogatory evidence are always answered in the affirmative at the commencement of proceedings. Canon 2541. Prior to the commencement of any formal proceedings, either party may lodge documentary evidence providing it conforms to the form accepted by the juridic person and legal system. Canon 2542. Excluding testimonial and inferential evidence, physical evidence is generally excluded from being entered into a formal proceeding after it has commenced after pleadings unless the knowledge of such physical evidence is divulged through testimonial evidence and it can be reasonably argued that such evidence would have been presented as part of defense or prosecution if its existence were known. Canon 2543. The withholding of relevant evidence is an offense and grounds for dismissal. Article 173, Admission. Canon 2544. Admission or admissibility is the formal acceptance by adjudication of any evidence presented as part of an argument. Canon 2545. Admissible evidence is relevant evidence that complies with the rules of relevance and integrity of existence defined by these canons. Only admissible evidence may be presented in all ecclesiastical, civil and criminal matters. Canon 2546. Alleged evidence where its relevance and probative value is substantially outweighed by the danger of unfair prejudice may be excluded from admission to the proceedings at hand. Canon 2547. Alleged evidence obtained under duress relates to any verbal, written, video evidence obtained from a witness and/or suspect by law enforcement, court, or other officials in circumstances where the man, woman, or person was deliberately placed in a state of actual or implied pressure or fear in order to gain a response is not permitted to be admitted as evidence. Canon 2548. Alleged evidence obtained without proper warrant, cause or authority to search and seize such evidence is not permitted to be admitted as evidence. Canon 2549. In ruling upon the admissibility of evidence, the judge shall not discuss or comment upon the weight of the same or its bearing in the matter, but shall simply decide whether or not it is admissible, nor shall they, at any stage of the proceeding previous to the return of the verdict, make any remark to convey to the jury that will influence their opinion of the matter. Canon 2550. In ruling upon the admissibility of evidence to be presented to a jury, a judge or magistrate shall not apply any limitation or weight to restriction based on the presumed level of jurisprudence and professional legal knowledge of the jury. Instead, the admissibility of evidence before a jury shall be the same as if it were being presented to for admission before a panel of judges. Warning, empty page. 6 Argument. 6.1 Argument. Article 174, Argument. Canon 2551. An argument is one or several connected postulations to influence the opinion of another upon faith, or to support a proposition as proof. A postulation may be based on one or more facts, or suppositions, or a combination of both. Canon 2552. As all arguments depend upon meaning, all arguments are by definition fictional, regardless of whether they seek to influence upon faith, or proof, or both. Canon 2553. The ability to present coherent and connected postulations is essential to any idea, model and system based on meaning. Therefore, the validity of an argument may be equated in some degree to the value and validity of a model, idea, or system. Canon 2554. As all arguments are by definition fictional, the test for the validity of any argument may be based upon such qualities as its coherence, comprehensiveness, relevance, consistency. The age of an argument, or its customary acceptance is insufficient evidence alone for its validity. Canon 2555. An argument that is consistent with these canons and conforms to the prescripts of Pactum de Singularis Coelum is superior to any argument that is inconsistent to these canons. Article 175, Cause. Canon 2556. A reason or cause is any alleged fact or facts consistent with natural law employed as an argument to justify and explain an action or act. Canon 2557. All divine immortal spirits expressed in trust into a flesh vessel possess the ability to reason, except those physically constrained by severe injury or disability. Where a man, or woman is unconstrained by severe injury, or disability, it is expected they accept self-determination and the exercise of reason. Canon 2558. The reason of the law ceasing, the law itself ceases. Canon 2559. No proceedings in law may commence without due cause. Article 176, Interpretation. Canon 2560. Interpretation is the use of argument, reason, logic, and competence in accordance with these canons to deduce the correct intent and meaning of the law. Thus, to interpret the law is to explain and apply the law as it was originally intended. Canon 2561. The best interpreter of a valid canon is the canon itself. Therefore, the best interpretation of any administrative act, statute, or ordinance is its conformity to these canons first and secondly to itself. Canon 2562. Conformity to these valid canons, not use, is the best interpreter of things. Therefore, custom alone is the worst interpreter of the law. Canon 2563. In the construction of valid agreements conforming to these canons, words are to be interpreted against the person using them. Canon 2564. Lawful commands in accordance with these canons receive a strict interpretation, but unlawful may command a broad and extended interpretation. Canon 2565. When anyone references, writes or speaks of interpretation, valid interpretation, or correct interpretation, it shall mean these canons and no other. Canon 2566. It is an invalid interpretation which corrupts the text of any canon. Article 177, Proposition. Canon 2567. A proposition, also known as a prot-asis, is a form of words or symbolic variables by which an expression of meaning, also known as the predicate or premise, affirms or denies an assumption of fact concerning an object or concept, also known as the subject. The words or symbols used to construct and connect the expression between the predicate and subject are known as the copula. Canon 2568. The word proposition is derived from the Latin propositio, meaning purpose or theme. However, the original ancient Greek word used by Aristotle when describing a proposition, in his invention of syllogism, was prot-asis, from pyro tau alpha sigma iota, prot-asis, meaning to put forward, tender, to propose. Canon 2569. The word predicate is derived from the Latin predico, meaning to mention beforehand, to prearrange, to foretell, to warn. The word premise is derived from the Latin premisum, meaning to send in advance. Canon 2570. The word subject is derived from the Latin subicto, meaning to lay under, put to throw up. Canon 2571. The word copula is derived from the Latin copula, meaning rope, leash, grappling iron/anchor, or binding. Canon 2572. In the context of logic and argument, the word sentence is wrongly argued as being equivalent to the word proposition. The word sentence is derived from the Latin word sententia, meaning way of thinking, opinion, or sentiment. Therefore, sentence by its original and true definition implies a predisposed bias towards an argument which is incompatible with the independent and objective testing for truth or falsity of an expression. Canon 2573. In the context of logic and argument, the word statement is wrongly argued as being equivalent to the word proposition. The word statement is derived from two Latin words statuo, meaning to determine, appoint, to decide, settle, to decree, prescribe, to judge, consider, conclude, and ment, is, meaning mind. Therefore, statement by its original and true definition implies a judgment or conclusion in mind before the facts have been tested on their merits, being incompatible with the concept of proposition. Article 178, Conclusion. Canon 2574. A conclusion, also known as a deduction, is a form of end, finish, result, or decision derived through inference and the application of logic and reasoning. A conclusion is also the third proposition of a syllogism, deduced from two prior premises, major and minor. Canon 2575. The word conclusion is derived from the Latin concludo, meaning to shut up, to enclose, to end, to round off. Canon 2576. A form of end, finish, result, or decision that is not derived through inference and the application of logic and reasoning cannot be defined as a valid conclusion. Canon 2577. All arguments as matters of law must be resolved through valid conclusion. Article 179, System. Canon 2578. A system is a set of interdependent and specialized objects or concepts that can be defined within some boundary as forming a unity, also known as an integrated whole. Canon 2579. All systems share the same elements, being I. Rules of classification and behavior by which the system itself and its function may be defined. And 2. A boundary or limit which defines those objects or concepts within the system and those excluded from it, and 3. Structure by which the objects or concepts exist and conform within the system, and 4. Relationships between the various objects and concepts, and v. Dynamic behavior and interactivity between the various objects and concepts, and 6. Purpose for which the system primarily exists. Canon 2580. All forms of valid argument are derived from valid systems of argument. Canon 2581. All valid systems of argument may be divided into either bivalent or multivalent systems, determined by the outputs of any given argument. Bivalent systems such as logic produce just two choices, being an A or B outcome. Multivalent systems such as most forms of natural systems produce more than two choices, such as an A and/or B to some degree outcome. Canon 2582. All valid systems of argument may be defined by their influence on the conclusion of any propositions as either passive or active. Passive systems of argument seek to remove deliberate bias to enable the most objective conclusions from given inputs. Active systems of argument seek to impose certain bias to ensure the desired conclusion is achieved. Article 180, Validity. Canon 2583. Validity is the quality of a form being valid, namely strong, authentic, and genuine, as such form is capable of being justified and proven to be true through logic and reason. Hence, valid arguments possess legal force. Canon 2584. An argument declared valid on claimed force of law alone does not make it valid. Not only must such a body of law itself be proven to be valid, but the arguments by which the law is used. Canon 2585. Valid is equivalent to testing and measurement. Validity is impossible without the existence of some objective measure. Canon 2586. Belief and faith are irrelevant to validity. Validity is a test of the strength of a form, not its popularity. The more comprehensive a model, the more logical, reasoned and perfected, the more valid, regardless of whether such a model of law is believed or not. Canon 2587. Any form of law based upon belief and faith that is tested against an equal or larger body of law, based upon logic or reason, by definition is less valid. Canon 2588. Any form of law that is inconsistent and contradictory to these canons cannot be law and is henceforth invalid. Article 181, Maxim. Canon 2589. A maxim is a term used to describe a self-evident axiom or premise constituting an expression of a general principle or rule in accordance with these canons. Canon 2590. By definition, all valid canons that precede or follow this canon are maxims. Canon 2591. A maxim is not a maxim but an inferior statement or claim if it is not in accordance with these canons. Canon 2592. The claim a statement is a maxim through custom or acceptance has no validity unless it is in accordance with these canons. Therefore all claimed maxims of law are hereby null and void unless they conform to these canons. Canon 2593. No statement that is claimed as a maxim of law may be used in a competent form unless it is a valid canon. Canon 2594. When anyone references, writes or speaks of a maxim, or maxim of law, or maxims, it shall mean these canons and no other.